Divorce TV with Wally Marcus. Divorce Estate Planning with Attorney Annalisa Moore Masunas. Support for Divorce TV provided in part by the Center for Divorce Mediation, 520-577-1202. Welcome to Divorce TV. I'm your host, Wally Marcus. I've been a divorce mediator for over 25 years. It's hard to believe. Approaching 30, I guess. And our topic today is a very interesting one. It's divorce estate planning. It's one that we don't think a lot about, but which is a very, very important issue. And I'm honored to have as my special guest one of the top people in the field in Arizona, Attorney Annalisa Moore Masunas. And you can get more information about her by going to our website, which you'll see at the bottom of your screen right there. And we'll flip on the screen occasionally your information so people know where to reach you. And you also now have been posting the shows on YouTube, so you can get it at youtube.com/divorcetv. Annalisa, once again, thank you for coming. I really appreciate it. Can you tell us a little bit about yourself?
Certainly. I am a native Tucsonan, actually, so I was born and raised here.
That is unusual. You're in a minority there.
Yes, I went to college at the University of Arizona, and then I went to law school here as well. And I've been an attorney for 13 years, and I am partners with my sister in our firm, Moore Masunas and Moore. I am a certified family law specialist and focus my practice in the family law area, and my sister handles estate planning, so we do
you can cover
those
all the
two
bases.
areas.
And I guess your husband has a baseball background, if I recall, too, so I think covering all the bases is an analogy here. But I always sort of throw my guests a little bit off guard, but it really occurred to me as you were saying that, what is a certified? I don't think we've ever discussed that before. What is the certification in Arizona? Does people understand that?
Sure, that's a process through the State Bar of Arizona. In different areas of practice, and my area being family law, you go through a process with the State Bar to become a certified specialist. You have to go through a peer review process, a written exam, a review of all of your cases and settlement by the State Bar, and so then you're certified as a specialist in that particular area of practice.
So it's a good thing for people who are looking for an attorney to look for that designation,
yes,
that they know that their attorney really is on top of what's going on.
Definitely.
That's good.
Yes.
That's important to know. Estate planning, I know, comes up on that one, but what are issues that people should consider if they're divorced and they have estate planning issues? What are some of the ones? We'll come back in more detail, but why don't you just give us a little overview?
Anytime someone is going through a divorce, that's one of the major life events that would cause you to change estate planning. So during the divorce process, one of the first things that you need to consider is making changes to your estate planning documents. That would be any powers of attorney that you may have, a general, durable, or financial power of attorney, healthcare powers of attorney, both for physical and mental health care, and also minor child powers of attorney. You also want to look at updating your will or doing a will if you don't have one, as well as a trust. If you have a trust, perhaps changes need to be made to that. You also want to look at perhaps making changes to how property is titled.
Good. So let's come back and discuss those a little bit in detail. But when you start a divorce action, there's what's called the preliminary injunction.
Correct.
And that allows you to do certain things and allows you not to do certain things.
Yes.
In that one. In the estate planning field, what are some things that you can and cannot do? And I guess that depends. If the divorce action hasn't started, there may be some timing issues here that people should consider if they want to do it before divorce starts, too.
Yes, timing is very important. When one party files for a divorce, one of the documents that is filed with the court is called a preliminary injunction. And the petitioner, or the party who starts the divorce process, is bound to follow that from the point they file.
Both people.
The other person, the respondent, is bound from the point they are served. Preliminary injunction prohibits changes to insurance policies such as life insurance, health insurance, disability insurance, different insurance. You're not allowed to make changes once the preliminary injunction is in effect. And so often that's part of estate planning. So if someone is considering divorce, there are times they will make changes to those types of things before the process ever starts. They are prohibited once the process has begun.
Is that a heads up for somebody that if somebody starts changing their documents that maybe a divorce is coming down the road?
That's certainly a possibility.
So what are there things that are allowed that you can do?
Yes, you are allowed to make a will or do a new will, amend a will during the divorce process. You're allowed to update powers of attorney. If you have powers of attorney, you're allowed to appoint new agents to make decisions for you. And when you're dealing with assets, you can deal with any property that is your separate property or your half of the community assets.
Okay, we're in we show the show on YouTube as well, and Arizona is a community property state.
Yes.
And so that's an
Correct.
important issue.
Yes, it is.
On that one. That's good, and it's important to know these things, and it sounds like some of these things are fairly technical, so people really should seek an attorney or professional advice when they do these things, because it sounds like a potential for lots of mistakes if
yes, that's
if it
correct. And very often the attorney, if you have an attorney involved in a divorce case, that attorney is not going to do the estate planning. I happen to do it also because I practice with my sister and we handle those two areas. Most family law attorneys will refer someone to another attorney to do estate planning.
In a situation, the question I periodically get comes up at the point is, can one attorney do that for both, and especially assuming in a divorce case, they wouldn't have one attorney doing the plaintiff and defendants or respondent and petitioner's wills, would they?
No, you would not do both. In a divorce case in Arizona, when I'm representing someone, I only represent one party. In the divorce case, because I'm only representing that one party, I then would do estate planning only for that party.
But if an attorney told somebody that they could do the will for both of them in a divorce case, you wouldn't?
No.
Not a good idea.
I mean,
okay.
Certainly an estate planning attorney, a different estate planning attorney could do estate planning for two people, but not the divorce attorney.
Which is right. You talked about a lot of these different things that we need, and one of them is a will. Do people need a will, and what happens in a divorce case or in general, and what happens if they don't have a will?
Well, anyone over the age of 18 needs a will, because it does a number of things. If you die in Arizona or any state without a will, that's going to then subject your estate to what we call intestate succession, which means anything you have, assets or otherwise, are distributed according to the laws of the state, and you don't get to make a decision.
Can you sort of give us an example, of what would happen, let's say, if a couple didn't have a will and they had, let's say, one child or something like that, or no children? What
Sure.
In Arizona, what would happen?
Well, everything would go to the surviving spouse if the child is a child of the two parties together.
Okay.
If someone is married to one person, has a child with that person, but maybe another child with someone else, different laws would apply. But when you're going through a divorce, if one spouse dies and that spouse does not have a will, then everything goes to the surviving spouse if they just have
It seems like it's interesting, because I think what ends up happening here is that people are fighting through a divorce where they're fighting over the property, and it sounds like if they haven't taken care of the will, that the results that they had might be very, very different than what they've been fighting for.
Yes, you bet. And that's when I am meeting with someone in the initial appointment for a divorce, whether it's in progress or potentially coming, I always advise to update your estate planning, because it does happen. People do occasionally die during a divorce process, and the results may not be at all what that person would have wanted.
And especially if the people don't have a will at all, then they could still be the same thing. They have an intestate issue as well.
That's right.
On that one.
Yes.
So when you say they actually should execute the will as soon as at what point would they execute the will?
Anytime they want to. I mean, if someone has made a decision that they are going to go through a divorce process, they can do a will at any point. Even if they're not going to go through a divorce process and maybe they're in a marriage that is not happy, if they do not want their half of the assets or their separate property to go to their spouse, you can do a will at any point.
Are they going to have to do another will after they get divorced? What happens if you have a will and then you get divorced? What happens to the will?
Nothing happens to the will. If you do a will during a divorce process, you would at that point note that you are in the process of getting divorced from the other person, and if you update it again after a divorce, it would just say that you're a single person and name maybe your children. But if you have done the update before the divorce, with everything as you would want it, you don't necessarily have to do it later.
What would happen if somebody had a will, didn't change it during the divorce, and then got divorced? Does the divorce affect the will at all?
Not necessarily. You do need to update
If you left
your
everything
estate
to your
planning.
wife, but
right.
if suppose somebody, husband,